episode on the law rapport. It has been a while since I have uploaded a video. Today I would like to speak about the duty to act in criminal law and if such a duty does exist. And when I did defenses in criminal law, I touched briefly on this, but very recently I was asked the question if there is a general duty to act in criminal law in the English legal system. But before I go any further, my usual disclaimer: this is not legal advice, should not be construed as legal advice, and for legal advice, please contact a competent attorney of your choice. Now, the English law does not recognize a general duty to act. There has been a great deal of debate over the extent to which criminal liability should be attached to an omission or a failure to act. One explanation might be the difficulty in determining the nature and extent of the general duty to act if such a duty is imposed. There might be questions as to what is the reasonable response expected of a defendant placed in such a situation where there was a general duty to act. There could be limitless liability if a general duty existed, and it could pose difficulties in enforcing such a law. Nevertheless, the argument could easily be made, in my respectful view, that it is in the public interest for members of society to help each other. So the question then arises, in my respectful view, when should a moral obligation become a legal duty? The courts have continually frowned on such a general duty, but have readily imposed a duty to act in specific circumstances. In the case of the Queen and Miller of 1982, Lord Diplock indicated that the court and the English legal system have not yet reached the point where a general duty is to be, or a general duty has been imposed on anyone to act in any given circumstances. And Lord Diplock said in that case of Miller, the conduct of the parabolical priest and Levite on the road to Jericho may have been indeed deplorable, but the English law has not so far developed to the stage of treating it as criminal. And for those of you who are religious or who know your Bible story, um, etc., you will know the story of the Good Samaritan. And Lord Diplock was simply saying the failure of the others not to act in the circumstances may be a moral failing, but the English law have not seen such as a criminal act. What would or what does the duty to act entails. Because, as I said previously, in very narrow circumstances, the criminal law under the English system does impose a duty to act, but it is not a general duty. So, the duty to act in criminal law is an obligation to act, under which failure to act or an omission, failure to do something, may result in criminal liability. Such a duty may arise by a person's status in relation to another person or a relationship between parties. It may arise by statute or it may arise by contract or, interestingly, by voluntary acting to assist the person, thus isolating that person from help, or by isolating that person so that others are not in a position to help that person, and thus creating danger. The vast majority of situations where a defendant is under a duty to act is likely to arise from statute, from laws passed in Parliament. And if a statute imposes a duty to act, then a failure to do so would be a criminal offense. An example would be under the Children and Young Persons Act of 1933, Section 1, United Kingdom of England Wales legislation. It makes it an offense for a parent or guardian to fail to provide adequate food, clothing, medical aid, or lodging for a child under their care. In the Turks and Caicos Islands, the duty to act will follow the English law. And in the absence of any special legislation, the common law position, in my respective submission, will prevail. Many decisions by the courts in the 19th century showed a general reluctance of the courts to hold an omission as being criminal. But there was the case of the Queen instance in 1893, where the defendant in that case allowed a relative to die by not feeding her. The adult niece was found guilty of manslaughter. And she was found guilty on the basis that she had accepted her aunt's money to pay for their food. She was not thus entitled to apply it all for her own use. This generated this relationship where she took the money, etc. The court held that it generated a duty of care from the niece towards the aunt, and the intentional neglect of the aunt by the niece was consequently a crime. Lord Coleridge, Chief Justice at the time, in delivering the judgment, said that despite the lack of statute and precedent, it would be a slaw on the justice system, or a slaw on justice, where the niece behavior or war the niece behavior to go unpunished. it would not be correct to say that every moral obligation involves a legal duty, but every legal duty is found an immoral obligation, according to Lord Coleridge. In modern times, the House of Lords, in the case of the Queen and Miller, gave recognition to the principle that a failure to act can result in criminal liability. In this case, a squatter of a tiny house fell asleep while smoking a cigarette, resulting in a small fire starting on a mattress. Rather than putting out the fire, he simply moved into an adjacent room and fell asleep, resulting in the house catching fire. The defendant was charged with arson under the Criminal Damage Act of 1971. He was convicted and he appealed. In dismissing his appeal, that the failure to act could not generally result in criminal liability, Lord Diplock stated the following: I see no rational ground for excluding from conduct capable of giving rise to criminal liability conduct which consists of failing to take measures that lie within one's power to counteract a danger that one has oneself created. If at the time of such conduct one's state of mind is such as constitute a necessary ingredient of the offense. So, in other words, Lord Diplock was saying that if a person creates a dangerous situation and fails to take action to mitigate the risk, then in those narrow and prescribed circumstances, the person could and would be guilty of failing to act because he will then have a duty to mitigate the risks that he or she themselves created. And so, in such circumstances, a person would be guilty if charged. It has been suggested by legal scholars, as I alluded to previously, and it is the view of criminal practitioners that the principles set out in Miller are likely applicable to any instance where an individual, in negligently creating a risk, fails to take steps that any reasonable individual would to avoid the risk to others. Whilst no general duty would exist for an uninvolved individual to try to stem a fire or to call the fire brigade, it is the causal link between the individual's action in creating a risk which result in a duty arising to prevent others from harm. So, a bystander, innocent bystander, someone passing and sees a house on fire, he has no general duty in law to act. And if the house is destroyed by fire, or even if someone lost their life in that house, he would not be liable criminally because he did not create the risk, and his failure to not to take any action, not to alert the fire authorities, not to call for help and what's not, would just be a moral failing, but it wouldn't arise to a criminal action. So in conclusion, while there is no general duty to act In English law, the court has shown a willingness to impose criminal liability in circumstances where the nature of the relationship between the parties may give rise to an expectation to act, and such failure to act creates an omission that rises to criminality. This has been a very short episode. I hope I was explicit. I thank you for listening. Please share, please comment, and please like this video. And I'll see you very shortly in another one. Thank you.